This is Quorum with Quorum's Quorum. My guest today is Ryan McCarl. Ryan's a founding partner at Rushing McCarl and the author of Elegant Legal Writing. Now, when I saw this book came out, I said to myself, another book on legal writing, but after reading it, I was impressed and I wanted to sit down with the author to learn more. Here's Ryan.
Ryan, it's great to sit down with you and talk, although you're standing, which I admire. I'm really excited to talk about your book and talk about your story.
Thank you for having me.
So your book, we're sitting out here because you published a book and it's called Elegant Legal Writing. What do you mean by elegant? What's elegant?
So the word elegance in the sense that I'm using it refers to tasteful simplicity in the choice and arrangement of words. I think that's a quote that I have in the introduction from the Oxford English Dictionary. I think accurately describes what I'm going for in legal writing, what I recommend. What I recommend is in line with what legal writing gurus and professors have taught for decades in terms of writing in plain language, disposing of unnecessary jargon and legalese. And that's kind of the simplicity part, and prioritizing clarity and readability. But I also believe that once those values are satisfied, you can also you should also think about aesthetic considerations, because one of the constraints that judges face, in addition to limited time and mental energy, is motivation and attention span, just like the rest of us face here in the digital age. So it's important, if you can, make your writing enjoyable to read by following good aesthetic practices and just paying a little bit more attention to considerations typically not considered, like pacing and writing in an engaging way, and ensuring that the brief really has a forward movement effect in terms of how its prose reads. That will make it more likely that the judge prioritizes reading your brief, actually reads it instead of skims it, and then actually completes it, and it'll help your message get through. The judge has to first read your brief to some extent, and then understand your argument in order to be to have the possibility of being moved to accept it.
Mm-hmm. Are there any litigators that you find to be consistently to be elegant writers?
I think I really have always loved Ross Guberman's book Point Made, which I've read and listened to many times since I was in law school. It's filled with great examples of appellate litigators who write in a way that's lucid and engaging. I've found the U.S. Solicitor General's office that does a lot of Supreme Court advocacy traditionally has been at the forefront of good legal writing practices and oral advocacy practices. And I also find that litigators at top firms, elite firms, Gibson Dunn, for example, tend to use best practices as far as focusing on plain language and writing briefs that show a greater attention to the nuances of language than you would find in sort of more typical firms. So I don't have any specific litigators who I tout as writing one way or the other. But when I search for good examples, sometimes I get them from my own firm's briefs, Rushing McCarl LLP. But if I'm looking for examples for the book or for teaching, I will often go to Lexis or Westlaw into the brief search tools and search for whatever procedural posture that I'm interested in, and then couple it with the name of a elite firm and flip through them until I can pretty quickly identify an example of writing that's not turgid and unreadable, which is kind of the norm in our profession.
Is there any subject matter of litigation that you tend to find the practitioners in that space are particularly good writers?
I would say that the constitutional litigation to some degree, although I don't practice as much in that area. But the fact that a lot of a lot of attorneys who focus on constitutional and appellate litigation are writing appellate briefs and arguing at the appellate level. Sometimes they're a little bit more in tune with good legal storytelling practices, for example, and they may write for courts that that have very high standards and expectations in terms of the argument, and they kind of rise to the level of the competition when you're talking about people that are arguing before the Supreme Court. So that's the first example that comes to mind. And I would say that there's other areas of law where writing in a lucid, engaging way is especially a challenge. So those would include patent law, for example, both challenging to explain the facts about an invention if you don't have a science or technical background in the relevant area, and also any kind of area of law where it's developed in kind of a convoluted way, or you're interpreting a convoluted statute or contract. I really relish the opportunity to write briefs in areas like that because of the challenge they pose. But it has to be understood that stuff is hard to read inherently. It's substantively complex. So the advice that I give to attorneys is the more substantively complex the information that you're conveying, whether it's, the area of law in general or the specific point you're making, the more you should really ensure that your sentences are syntactically simple and your paragraphs are short and focused, and you've, really ruthlessly weeded out any unnecessary complexity and detail, because you want to chart a path for the reader, the judge, through the relevant law rather than sort of adding complexity with the language, which is more what typically occurs.
Mm-hmm. And you mentioned Ross Guberman earlier, and so he came and did a training at my firm. I think this must have been 10 years ago. I had a really positive impression of it. I don't really remember what points it took way in corporate in my practice. Again, this is like 10 years ago. But, I'd be curious to hear from you. What are there's people like Ross Guberman, there's Brian Garner. I think those are two of the bigger names in legal writing. What do you see as their key innovations or contributions? In what ways is your book a departure from their point of views?
So I've read both of their work extensively and so many times. It's sort of it's integrated into my framework for thinking about writing for the most part. Ross Guberman's book Point Made, and then the later book he wrote about writing for judges, which follows a similar tack, is the particular strength in my view is his mining of good examples, like I mentioned earlier, and his deriving from those examples of sort of advocacy moves. So one of the first ones he talks about, for example, is, he calls it, I believe, one fell swoop, where you distinguish an entire line of precedents at once by finding the common thread that makes them distinguishable rather than going piecemeal through each case. And it's just those simple little touches that make that simplify an argument and simplify the problem space, you could say, for the judge, and gives them a way to think about the case in a way that aligns with how you want them to. So I think that's a sort of different project a little bit than what I have done in Elegant Legal Writing, where I focus more on there's obviously some overlap, but I focus on first prose mechanics, prose aesthetics, how to actually write concisely and clearly, nuts and bolts of how to write good sentences and paragraphs and how to organize documents, followed by a few chapters on substance, tips about substantive argumentation, substance of using legal authority, how to write good fact sections. And then I also dip into a few topics that aren't covered as much in most other books on legal writing, like writing productivity, using technology in advanced ways, and then legal typography and design of documents. So, but the unifying theme of my work is that of Elegant Legal Writing is that judges have cognitive constraints and time constraints, that, the same ones that all readers face, but they're particularly acute for judges. So what's important is to show the judge that you're going to be helpful and then make your point very quickly, and then write your brief in a way that is considerate of their time and their energy, and that is designed to hold their attention, and that is a aesthetically pleasing experience, right down to, the font you choose. As for Brian Garner, he's sort of the traditional guru of the profession in the recent decades, and I've read a lot of his books and learned a ton from him. I think that he's done a great deal to make plain language principles the expectation and norm in elite legal writing. So that's kind of what I would say is what I take to be his one of his central contributions. He also is an expert in things like lexicography and word usage. So his book Modern English Usage, for example, is on my shelf and frequently used, full of tabs. He just has gone into great depth, kind of in a way that Ken Adams has done in contract law. Brian Garner has done with legal language more generally. And I found that to be really, really helpful. Another thing about Brian Garner that I've appreciate and have built on a bit is his challenge to the traditional hostility to footnotes in the legal profession. Mm-hmm. That is a very well entrenched practice in the legal tradition and in litigation of avoiding footnotes and putting everything in the main text on kind of various theories that judges don't like footnotes or whatever other reason. And Brian Garner did a lot to move the profession away from that by saying, well, there shouldn't be substantive footnotes, but at least we should put reference material in footnotes. I actually go further than that in my book, and I discuss that in a section on footnotes when I cover document design. But I believe that actually there's no real good reason for the tradition's hostility to footnotes, and that footnotes are a great way to increase visual variety in a brief, but more importantly, to help signal at a glance to the judge what are the most important parts of this brief. So in case the judge has to read it quickly or only reads it once, and is only going to devote 15, 20 minutes to it, what do you need to convey to the judge versus what is secondary, whether that's reference material or whether it's an argument you're making just to avoid waiver or a response to a kind of an insignificant contention. In my view, quite a few of those, there's quite a few use cases for footnotes that fit with the basic principle of using design to communicate what is most important for the judge to read and understand.
Mm-hmm. What is just at a high level, I'll mention the parts of the book. You've got style, which includes aspects like concision, plain language, tone and professionalism. And you have substance, which includes aspects like using legal authority, legal storytelling, and process, which is the mental game of writing with technology. So style, substance, and process. What in this book, or is there a specific point that you think is important that you think that people are most likely to disagree with?
Well, the footnotes one, of course, is definitely a conversation starter because it goes further than other legal writing experts have, and certainly further than most litigators do. But I think, as with using plain language in general and avoiding legalese, I think you see if you look closely at how the top advocates, people who argue frequently before the Supreme Court, people, who get paid $2,000 an hour at places like Wilmer Hale or Gibson Dunn, how are they writing? And you'll find a lot of footnotes, just like you'll find a lot of writing that's closer to, for example, to a New Yorker article than to a traditional legal filing. And so I think that, my take on the footnotes is still controversial because no one's kind of come out and said it, to my knowledge, and said, go for it. Every other academic field uses it without a problem. And it's an obstacle to readability to put reference information or asides in the main text on the same footing from a design perspective as the core points. But it is different than what people have said before. So it gets a lot of attention. Another point I make in there on the chapter about briefs and motions is that I've really I challenge the IRAC and CREAC paradigms and similar argument organization paradigms that are still being taught to law students. And you often will see, for example, on LinkedIn, you'll see a lot of people who write about legal writing still kind of advocating just follow IRAC. And I just don't agree with those, with that. I don't think those are actually that helpful a framework to when you're, whether for thinking about legal reasoning or thinking about how to organize an argument. I find those to be oversimplified and typically to kind of miss the point of most arguments, because if it were just as straightforward as applying a known rule to known facts, there wouldn't be a whole lot to argue about. So most of the meat of a contested legal argument in a hard case is going to be arguing about the nuances of what a rule means and how that interacts with the facts. And it's just not that helpful, in my opinion, to kind of think. I think that some people, when they think about IRAC or HUIAC, they tend to kind of juxtapose the rule, what they say is the rule versus what they say are the facts, and say that, together these support the conclusion. But everything within that everything within defining the rule and then defining it in light of the facts and mutually adjusting the characterization of the facts and the characterization of law, that's really all the meat of analysis. So I propose a different approach, which is to think about it more in terms of traditional informal logic and thinking about it as conclusions plus reasons. So you do lead with a conclusion, and then you support it with the reasons that lead to the conclusion in order of strength. And what is a reason? A reason to accept a legal conclusion is typically a combination of kind of interweaved legal premises, which are rule statements, and fact premises, which are the facts of the case.
Yeah, that makes a lot of sense. I think about how I applied legal writing to other domains. So, for instance, the first comes to mind is that I've got some short-term rentals, and there's oftentimes when I need to interface with the platforms or vendors, or just there's different stakeholders that need to reach out to resolve an issue. And when I write to these people, I'm not, I'm using my legal writing skills, but I'm not, you're right, doing some sort of IRAC kind of style of analysis. It is much more like you're saying, like, here's a conclusion, and then here's the interweaving fact and rules. But I lead with a conclusion because there's like a call to action. Here, I'm looking for this outcome, and here's reasons why. And so I think I think if you think practically about how you would persuade someone, not just like, hey, this is what I was told to do to persuade someone, just like, how would you, if you're trying to persuade someone, not only marshal authority, but also frame, I want this thing done for clarity so they know what you're looking for. It would probably follow exactly what you're saying in that sort of order.
Yeah.
Let me ask you this.
Absolutely. In the call to action analogy.
Go ahead.
Oh, I'm sorry. So the call to action analogy you made, I think, is actually quite helpful. I've dabbled a little bit in web design, user experience issues like that, both because I did have a startup, a web startup a few years ago, but also just in the course of researching for elegant legal writing, I did some dabbling in design issues. I had books about design, and to try to understand how design principles could be used to inform how we write briefs in a way that's going to make them easier to read, help us get our messages across more clearly, and more pleasant and enjoyable to read. And so the call to action idea from web design and marketing is to have a very clear ask, right? That the reader the reader of a web page, for example, doesn't have to look very hard or very far or wonder what you want, because it's very clearly stated. I think that in law, the same exact principle applies. A judge, you're putting, when you write a motion, when you're writing a motion or seeking legal relief, the first question the judge will have always is, what are you asking me to do? And what are you asking me to specifically hold, versus both in terms of the particular ruling, and then the remedy, and then why is the next question that they have. Why should I do that for you? And why are you right, and why is the opponent wrong? And that's, to me, follow the conclusions plus reasons paradigm that I mentioned earlier. Just follows that logical structure of what a judge needs when they open the brief. They need to know what you are asking them to do, and then they need to know why.
Yes, that's good. And so again, with this style, substance, and process conception, what do you think is your competitive advantage as a writer?
I think that for me it's the fact that I've been teaching for a long time at different levels. So before law school, I taught ninth grade and 10th grade history. And, now I sometimes teach law school, advanced legal writing courses, teach CLEs. The book itself is an exercise in teaching, as is my blog, elegantlegalwriting.com. And that's part of it, is thinking about how to reach, learners who might be tuned out or who might be skeptical of the importance of this topic, and, or who may not have yet the complete sort of framework and mental schema for thinking through a problem that you have as the teacher or the writer. So I think that's part of it, is thinking about how to motivate somebody to want to read what you say, and then how to quickly convey the essential information in a way that learning is not such a we're not depending on the reader's self motivation. Really, we're helping them learn almost inadvertently, because you get their attention, and you quickly convey what you need to convey, while addressing any problems or any potential lapses in comprehension as early as possible. So that's kind of part of it. And I think the other part of it is that I love language, and love just lifelong reader and writer. And I've taken creative writing, workshops, written parts of a memoir, for example, done a lot of workshops and a lot of reading about general composition and, fiction writing, poetry writing. I actually took poetry workshops at the University of Chicago when I was in law school, for credit, which was pretty cool. And that sort of being highly attuned to language and then thinking about how to write for aesthetic reasons that are separate from making legal arguments. I think there's a lot of wisdom in those sources, in books about general composition, in fiction workshops, and so on, that it doesn't take a whole lot of imagination to apply them to your legal writing, and allow some of those techniques about pacing, rhythm, emphasis, and so on to shape the way you communicate your message. Aesthetics are always going to be secondary to substance in legal writing, but usually I argue in the book Elegant Legal Writing that they're more intertwined than people think, and that usually you can convey difficult ideas in a way that is still pleasant to read, more aligned with what you'd read again in like the New Yorker or some other general nonfiction.
Mm-hmm. What's a nonfiction writer that's influenced you the most?
Oh, that's
let me clarify. Influenced your writing the most, I should clarify, because of course the nonfiction writer might have influenced some aspects of your life, but in terms of how you think you approach writing, which nonfiction writer you think has influenced you the most?
Well, there's some that have written about writing itself, which I mentioned in the the resources of the book, like Jacques Barzun and Joseph Williams are good examples of that. But setting that aside in terms of and thinking about not more general nonfiction writers, I would say I think it's to some degree, honestly, older. It's kind of quote unquote public intellectual writers, like these great essayists of the past. More recently, you might include Christopher Hitchens as kind of a more recent example. But going back further, people like H.L. Mencken, this very caustic kind of savage writer from the 1920s, 1930s. I think I wouldn't necessarily emulate his tone or misanthropy, but I would say his way of crafting prose is phenomenal. C.S. Lewis is another example of somebody who writes in a very lucid and engaging way. George Orwell is another example in his essays. Those, and then in terms of fiction, John Cheever's fiction, short stories, also very easy to read, lucid, gorgeous prose. And I could probably come up with quite a few others, but there's I really just appreciate artful prose such as that you find in the great kind of modern essayists from the past couple centuries.
And I really value that not only you're drawing from that sphere as influence, but you're also drawing from marketing and more well, not necessarily contemporary. I think these principles of copywriting are they've endured a lot, and some of the most skilled writers on the internet today cite to what they've learned from copywriters from 50, 80 years ago. Or people like, say, David Ogilvy. When you read his works, he is a very clear writer. And very persuasive as well. And so I think there's a lot to learn from both highbrow and, if you want to call it lowbrow sources about persuasion and clarity.
I do have Ogilvy on advertising somewhere on my bookshelf, as well as I said, like books on graphic design, and yeah, absolutely the basic, you should take wisdom wherever you find it. And the core principles of good design, good aesthetics, good prose. There's just a major shared core of wisdom and purpose. And the people who are working on, UX and marketing and design today, although quite different in terms of aims, audience, from some of the writers I mentioned, they're facing a challenge that is really similar to that litigators face, which is how do you reach an audience that does not have time or necessarily inclination to listen to you? How do you break through that noise? What all the distractions of modern technology, all the other things that a consumer might be doing instead of paying attention to your ad. It's a bit of a dark art sometimes in the world of marketing, but it's the same exact thing that trial lawyers have to do when you're trying to reach a judge who has, anywhere from 200 to 1,200 or more active cases.
Mm-hmm. So you've clearly been interested in writing for some time now. I'm sorry that I used the word clearly. I know you told me I shouldn't use that. But so when did you decide that you wanted to write a book on legal writing?
Well, clearly, to be clear, as an intensifier to bolster a conclusion, it doesn't provide backing. That's my issue with clearly. But as an adverb to describe a good prose style, I think it's just fine. When I decided to write a book about writing, it was probably back in 2020 when I was doing a 2-year fellowship in AI law and policy on the faculty of the UCLA School of Law. And I was able to, I don't remember exactly what spurred me to do it, except other than love of language. But I was able to convince the curriculum committee to allow me to teach an advanced legal writing course, which I designed from scratch. And in the course of developing that curriculum, and doing the research over the summer, just reading as many books on prose style in general, design and legal writing more specifically. In the course of doing that research and designing a pretty thorough curriculum to last an entire semester, and I tried to distill from all those sources that I had read and my own intuitions and experience, what were the most helpful principles for attorneys and law students to know, and ones that are usually oftentimes aligned with what stylists have said before, because this is a craft and there's a common core of shared writing advice on things like concision and plain language. But there's also a lot of practices that are just not the norm, and a lot of concepts that a lot of litigators just aren't really familiar with still, like things like thinking about emphasis, allocating emphasis in a sentence, thinking about sentence logic, thinking about rhythm. These concepts sometimes are maybe more familiar to people who have studied, taken like a creative writing course or two, but it's not covered in your typical 1L legal writing class. So I set out to try to distill the most helpful tips that I could convey my students to help make them ready to write at an elite level. And the process of doing that, I generated something like 400 pages of, of slideshows and handouts and so on. And I was able, and that pretty naturally, once the course ended, led me to look at that storehouse of stuff I had created and notes I'd taken and think about crafting it into a book.
Mm-hmm. Was there like a moment though that you said, "Hey, you know what? I think I can do this. I think I'm ready for this."
Yeah, I think back in early 2021, so that would be shortly after I concluded that course. That's when I started the elegantlegalwriting.com blog and announced that I was going to do it, to write the book. I've had many projects over the years, that, they always come and go. And I've always, my entire life, wanted to write a book. I mean, ever since I was 6 years old, probably, or earlier, that was my main goal in life in some ways, was to write books. But it's a challenging endeavor. It takes enormous focus and discipline to write. If you're trying to write a book through a traditional publishing method, with a major publisher, it takes years of trial and error, of conceptualizing, drafting it, getting the proposal accepted, endless rounds of revision. It's just a major undertaking. And you have to have a pretty deep love for the subject and a willingness to really put a lot into that. So I made sure that I was ready for that, ready to make that commitment, or as ready as I would ever be. And it worked out because I really found that in designing the course materials for the advanced legal writing course I taught at UCLA, and working with my students throughout the semester, I was able to really discover how much and how deeply I care about these issues, and also how much I knew about them, and recognize that I actually had the expertise to contribute positively to an already crowded field of people that write about legal writing, and that I had, because of my kind of eclectic background in different ways, and my my love of language more generally, that I had something new to say, in addition to helping to synthesize the work of others.
And I think any number of other writers, but any other number of lawyers would love to publish a book as well. Hopefully, maybe not necessarily on legal writing, because as you say, we've got a few of them. But so, what tips do you have for someone who's looking to work with a publisher? You work with UC Press, which I would understand is an academic publisher.
Mm-hmm.
So maybe some pros and cons of working with an academic publisher, or just more generally, what would you do differently or the same if you were starting over?
Yeah, so University of California Press has been a phenomenal partner from the beginning of this project. I think that I like I said, I tried to write a memoir once before. I wrote a part of a book on education back when I was in my mid-20s, after I got a master's in education from the University of Michigan before going to law school. So I've tried different ways of breaking into the world of traditional publishing that have sometimes gotten a little bit further, gotten my foot in the door, and, been invited to write a proposal, even had a proposal accepted at one point, but then ultimately at the end of the day, it didn't work out for one reason or another. So there's a lot of trial and error there. But what I would say is that you should make sure that you are an expert, or can acquire deep expertise in the topic, and have the motivation to do so, because you're only going to be able to write something interesting if you have a pretty good handle on what others have already said about it, so that you can build on that, and help to synthesize, convey it, and then build on it. That's the only hope you have of really being innovative and interesting, in my opinion, enough to get published by a traditional publisher. And then I guess in terms of actually thinking through the publisher, you want to look at their catalog to see who do they actually publish stuff that is in this area. And sometimes that what I encountered from a couple of publishers, academic publishers. I only actually approached like 4, but a couple of them had somebody who was kind of their go-to legal writing person in their catalog, and they said no for that reason. But University of California Press was a peer of those same academic publishers, and they were ready for another book on legal writing. So it worked out. Then what I had to do was to get it accepted was, it began with a query letter that then it turned into a book proposal, which was thoroughly vetted. Then I had to very quickly write a manuscript after the proposal was accepted in principle. Then it's just contingent on waiting till you have the manuscript in. And I had to very quickly turn the proposal into a full manuscript. Then it goes through a peer review process where there were 4 anonymous peer reviewers who provided detailed reviews and feedback. And then there was a vote, the internal vote in the press, and then they do even a faculty vote as well to get the book through into the point where you get a book deal. So it's a very long, arduous process with many opportunities for it to go wrong. Throughout it, you have to have a great deal of resilience and discipline, which is hard to come by, especially if you're a practicing lawyer. I find it hard in particular to work on projects where the payoff is completely contingent. And you may end up putting hundreds of hours into something only to have no book at the end of it. But I was able to get myself to do it because I love the subject, and because I was able, what really worked for me at every stage was recentering myself as thinking about being a teacher and thinking about helping people, as well, instead of thinking about ego-driven ideas of having a book. It turns out that it's really cool to have a book, and it has helped me build a great platform that is still growing quickly. But to me, that wouldn't necessarily have carried me through all the difficult times of trying to struggle to formulate a principle that I cover in the book, that I just don't really want to write about at the time. I know it's important. I don't really feel like writing about it. And I know that if I had that attitude, people aren't going to want to read about it. But to stick through that and fight through it and come out with something that that's going to be polished at the end of the day, to me, I had to think about helping people and about being a teacher. Once the book manuscript was accepted, then I actually rewrote the entire thing. Not one sentence, or very few sentences, I'd say, were that ended up in the finished book were there in the accepted manuscript, because once I knew that I was going to have this book come out, and I knew the close scrutiny that it would be under as a book in a crowded market aimed at busy people, about writing, no less. Then I rewrote the whole thing, and I just revised it millions of times with the help of a lot of editors.
What was the hardest phase of writing the book?
I think the hardest phase is probably the initial draft for me, because it just takes so much time. Every stage of it takes time, but with revision, you at least have some clay to work with and shape. But at first, it's just you and the blank page. If you're writing, I recommend in the process chapters of Elegant Legal Writing that litigators, start with templates and models. You don't have to completely reinvent the wheel every time you write a discovery motion, for example. But when you're writing a book, there's no template really. So if you want to write something, you have to create that skeleton, but then you have to fill it with actually fleshing out ideas. One of the things that I found difficult when I was a young associate, and in other settings that I've worked in, is when you're asked to write somebody else's ideas and flesh them out, because there's just a big difference between an idea in your head versus an idea that has been fleshed out on paper and communicated to a reader. And a lot of times ideas that are in your head turn out to be a little bit nebulous or more vulnerable or less sound once you actually write them down. So it's really that process of struggling to formulate the concept on the page and get that first draft on that I found to be the hardest.
Mm-hmm. And you mentioned, and by the way, I really love your Apollo 13 reference. I think that concept of, hey, we've got this square filter fit in this round whatever thing. That's a scene from the movie that I always remember the most. As a kid, I just found that riveting and so fascinating. And I like your comments and say, hey, the movie would be a lot differently. Just wouldn't be as interesting a story if just, they walked and say, oh, we're going to be able to do this thing. And then they did it. And then just, they didn't show any of the hard work that went into that. But we should be more like that, even though it's not as interesting to present that way, your final work product, that you should leave some things on the cutting floor. So, I really like that concept. Earlier you were talking about, the reasons why you wrote the book and reminding yourself of the teaching component and your inherent love of good prose was, probably the most motivating, most potent motivator for you throughout writing this book, which definitely sounds harrowing. And yes, it sounds like there's multiple points which, things could have just run asunder. But I'd be curious, you have your own law firm. What are the ways in which publishing this book has benefited your practice?
Well, people are finding my content useful on LinkedIn and in the blog, as well as obviously the book itself as the main source of it. But I'm continuing to develop new material for a future book on legal reasoning, and I'm continuing to find ways to expand on, refine, sometimes tweak recommendations that I make in the book, and talk about some of the tips that I have taught about before or talk about, but that are not in the book. And people find that content valuable. So that's motivating to see the level of engagement that it gets on LinkedIn. Sometimes, I've just maybe 3 to 6 months, about 3 or 6 months ago, I think maybe I had like 1,000 followers or something at most. But I wasn't that engaged on LinkedIn, didn't do a whole lot. Was never trying to really cultivate that. But I changed that a little bit in the ramp up to the book as a way of promoting it. And what I found was, perhaps because of the demise of Twitter, and the lack of other, really well-established social networks that allow for, people to share text, is that there's a pretty thriving community of lawyers that are on LinkedIn and are using it to engage with the profession, to share ideas, share tips, and sure, there's promotion of your firm and your practice and your writing, but it's sort of attached to useful content that actually adds value to people, and it's not pure marketing. I found that to be a really great way to meet a lot of attorneys, and a great way to kind of build an audience for the future. And my hope is that, and people have taken a great interest in the briefs my firm has written as a result of my writing about legal writing. So a lot of people have looked at the complaint we filed in our litigation, our putative class action case against the manufacturers of Stanley Tumbler Cups, or the amicus brief that we wrote on behalf of Coach Jim Harbaugh in the Michigan versus Big Ten litigation back in the fall. Those are already kind of inherently interesting topics, and it adds a bit of extra interest from the perspective of lawyers to find that, oh, there's a QR code in this brief or this complaint, or, where you can watch an Instagram. You can scan the brief and you can watch an Instagram post that is relevant to the complaint. What is this font that is not Times New Roman? Where things like that I think have brought our firm's work to the attention of a much broader audience. And so my hope is that over time those connections will continue to lead to referrals and continue to lead to bringing us in as counsel whenever there are high stakes motions to argue or trials.
Okay. And final question for you. If you could wave a magic wand and make a word disappear from every brief that's ever written from here on out, you never have to read this word again, what's the word you want to make disappear?
There are so many. Utterly. Probably utterly. I don't know. That could be it. There's a lot. There's so many. There are really so many. I list a lot of them, a lot of the worst offenders in the book. There are so many words that we use unnecessarily. I honestly, terms and conditions is another one. It's not a word, it's a phrase, but honestly, it kills me. Yeah, it's so ubiquitous. it kills me because of its inherent redundancy, because every condition is just a form of a term. Each and every, and what may be the worst offender in my mind as I think of it, this is a great question, because it just makes my skin crawl as I think of some of these practices. But, the practice of spelling out writing a number in dollar sign with a dollar, in a decimal, and then spelling it out as though you couldn't read the first time, you didn't understand the first time around, even though every third grader can read numbers. To me, it's just absolutely baffling tradition.
It also increases the odds of creating ambiguity, because you just added, if there's some percentage that is misunderstood, you're adding some other bit of text that also could potentially conflict. Like maybe I actually put the wrong number in. You're compounding confusion rather than clarifying. So
yeah. So whenever you repeat, this is something that that programmers, web designers know well. But if you have repeated text, it's good to have like a variable that you affect once, you change once, and then it's fixed everywhere. But as you're referring to, I think if you try to repeat the same number twice, you've just introduced the possibility that if you got the number wrong, now you have to remember to correct it in several different places. And if you're writing it out as a digit and as in and in letters, now you're find and replace operations not going to find both instances of it. So it's one of those sort of kind of senseless legal traditions that I'm not the first to say. I'm hardly the first to say that's got to go. That's something that Brian Garner's been saying for decades. But that's as well as legal writing professors. But yet it persists to this day, which goes to show that this is there are still lessons to be learned in this area, both lessons that have been taught and ones that are fairly new.
Yeah, that should make you feel very comforted as a teacher of legal writing that your job is definitely not over yet, and a lot more work to do.
Yeah, right. Nor will AI write your good briefs for you.
Cool. Well, Ryan, this is great. Glad we connected here, and congrats on the book, and best wishes on its success.
Thank you so much for your time.
Thanks.